Thank you for joining us today. As you join today's webinar, we will be getting started in about 2 minutes. Thank you all for joining us today. We are going to get started in about 1 minute.
Welcome, everyone, to the fourth in the fall webinar series for UCLA Law's Safeguarding Democracy Project. I'm Rick Hasen of UCLA Law School, and I want to thank Harley Ham for her important logistical support today. Let me tell you about a few of the upcoming programs of the project. All programs are online and free, but registration is required. On September 29th at noon Pacific, on October 14th from 9 to 1 Pacific time, in conjunction with Stanford Law School, the project will sponsor a conference, Should Donald Trump Be Returned to Social Media? And on October 27th at noon Pacific, I'll be in conversation with the New York Times' Maggie Haberman on the topic of Trump, Trumpism, and the future of American democracy. You can find all of these events to sign up at the Safeguarding Democracy Project website, safeguardingdemocracyproject.org. I'm going to begin today with an introduction and then ask some questions of our guest. You may submit questions using the Q&A function on Zoom. I'll try to get to those near the end. Today, I'm thrilled to welcome Representative Adam Schiff for a conversation on lessons from the January 6th committee. Representative Schiff is a graduate of Stanford University and Harvard Law School. After graduating from Harvard, he moved to Los Angeles, where he served as a law clerk to Judge William Matthew Byrne. He then joined the U.S. Attorney's Office in Los Angeles as a federal prosecutor, where he served almost 6 years. In 2000, Representative Schiff was first elected to the House of Representatives, where he has served ever since. His current congressional district is close to UCLA, includes parts of Glendale, Burbank, and Hollywood, among other areas. He currently sits on the House Permanent Select Committee on Intelligence. He previously served on both the House Judiciary and Foreign Affairs committees. Representative Schiff was the lead impeachment manager for President Trump's first impeachment, and he serves on the House Select Committee to investigate the January 6th attack at the U.S. Capitol. As it turns out today, the House is voting at the very time that we are holding this webinar, so there may be a few minutes in the middle of this where we'll have to take a short break for Congressman Schiff to vote. And with that, let me welcome Congressman Schiff. Thank you so much for being with us today.
Rick, thank you very much. It's a great pleasure to join you and to join the students. I look forward to the discussion today. My apologies that this class should coincide with a series of 16 votes. So if you see me having to check my phone periodically, it's to make sure I don't miss a vote, and I will be stepping off camera to vote happily. The floor is not far from where I am, and I can return very promptly. But very much look forward to our discussion today. And Rick, thanks again for inviting me.
Thank you. And I know that the January 6th committee is still planning on holding one more hearing. The last hearing was scheduled, or the last scheduled hearing was supposed to be yesterday and got postponed because of the hurricane. It will be rescheduled, and you haven't issued a report yet, as a report is not coming out, I think, we think until the closer to the end of the year. But I'm wondering if at this point you can just talk about, maybe from a 30,000-foot level, what you think the primary lessons are that have been learned so far from the investigation.
Well, first of all, I would say that what's most important for people to realize about January 6th is that it wasn't a date in isolation. This wasn't an isolated occurrence where a group of people spontaneously decided to descend upon the Capitol in an effort to delay or stop the joint session of Congress. But rather, this was the violent culmination of multiple lines of effort to overturn the election. Lines of effort that included the filing of bogus litigation all over the country. It included the establishment of fake electors who would portray themselves as certified electors from various states in the hope that the vice president would adopt those fake electors as electoral votes rather than legitimate votes of the states. Included an effort to try to pressure state legislatures to go back into session, make declarations of fraud, and certify a different group of electors. It included pressure on state elections officials, including one now infamous call between the former president and the Secretary of State in Georgia when the secretary was badgered to find 11,780 votes that didn't exist, but were nonetheless the exact number that Donald Trump would need to overtake Joe Biden. It also involved lines of effort at the Justice Department to decapitate the leadership of the department and replace it with leadership that would echo the president's false claims of fraud, and a vigorous pressure campaign mounted against the vice president himself to get him to assume duties that he doesn't hold during the joint session of Congress and simply disregard certificates of electors from states that Trump lost that were key to Joe Biden's victory. It was only when all of these other multiple lines of effort failed that the president resorted to the use of this mob and violence to try to stop the peaceful transfer of power for the first time in our history. So that broad, multi-layered effort to overturn the election is what we wanted to illuminate to the public so they wouldn't think this was somehow a protest that had gone awry and is somehow disconnected from other efforts to overturn the election.
So when we think back to what happened, it's very clear that there was some criminal activity. The low-hanging fruit here, the things that are obvious were the invasion of the Capitol, the destruction of property, the assaults on police officers. Do you see in all of the other things that you described, the fake electors, the attempts to try to get the Secretary of State of Georgia to change votes, do you see, as a former prosecutor, grounds for potential criminal charges, either against Donald Trump or against those who are working with him on these kinds of activities?
I certainly think that there is now very public evidence of criminal activity, of activity that violates a number of federal laws. Judge Carter, David O. Carter in California, federal district judge, in multiple opinions found on the basis of the limited set of evidence that he reviewed, that is the email communications from John Eastman, one of the lawyers working on these multiple lines of effort. He found that there was evidence to support potential charges for defrauding the United States, for interfering with an official proceeding, that is the joint session, with common law fraud. And I think that in multiple respects, whether it was the efforts in Georgia to get the Georgia elections officials to come up with votes that didn't exist, or the efforts in other states to put pressure on legislators to throw out the Biden electors. Yes, I do think that laws were broken. And one of the reasons I have been very critical of the Justice Department is they pursued early and with vigor those that broke into the Capitol that day, and those who conspired with them, and those who may have financed them. But it's taken them a very long time to investigate these other lines of effort. And here we are now, a year and a half since the events of January 6th. And some of those events, like the president's call with the Georgia Secretary of State, still seem to be under investigation predominantly by a local DA's office, the Fulton County DA. And, God bless the DA in Fulton County for having the courage to do so. But I've never seen the Justice Department defer to a local DA's office when it came to a case of national and federal significance. So yes, I think there's ample grounds for investigation and federal investigation and likely laws that were broken and potentially by multiple parties, including the former president. And I think they need to be vigorously investigated as they would be asked to any other American.
And let me ask you specifically about the potential prosecution of Donald Trump. One of the things that prosecutors have to look at is not just whether there are whether there's adequate evidence to bring criminal charges, whether there's probable cause.
President, you could excuse me 1 minute. I'm going to go vote and be right back.
If you're just joining us, we're speaking with Representative Adam Schiff. He is a congressman who is sitting on the House Select Committee investigating the January 6th insurrection. He's also, as a congressman, right now in the middle of a series of 16 votes that are being held on the House floor. And so timing is everything, they say. That's true in lots of areas. It's true in this event as well. And so we're just going to take a short break, hopefully under a minute, and then we will be back to continuing our conversation with Representative Schiff. Let me remind you that if you do have questions, you can submit those questions through the Q&A box, which is if you're watching this via Zoom. And I'll also remind you, since we have time, that the next event will take place on October 14th. Oh, wait, Congressman Schiff is back. He's a quick voter. We appreciate that. It's a good thing you didn't have to vote the California ballot, which has many more things on it. So I was asking about the issue of prosecutorial discretion and saying that to talk about potentially indicting a former president, you have to take into account not only whether or not there's enough evidence, but also whether or not it's in the country's interest. And of course, we know that in relation to a separate issue related to classified documents, Donald Trump has suggested that his supporters would not stand for his indictment. How do you think those factors should weigh? I'm not asking to weigh on if there's enough probable cause. We'll see what the evidence is. But just on this question of thinking about what it would mean in an unprecedented way to indict a former president.
First of all, I think we have to dial the clock back to when Donald Trump was in office. The time that he was in office, the Justice Department took the position, which I believe to be a flawed position, that as a constitutional matter, you couldn't indict a sitting president. And for that reason, Bill Barr argued, among other reasons, Bill Barr argued that the department couldn't go forward with the prosecution, and then gratuitously, and I think it quite at odds with the Mueller report, went on to say, and there's not sufficient evidence anyway. That conclusion, I think, would have come and did come as a bitter shock to Mueller's team that was not intending to arrogate to Bill Barr that decision. But if you take the position as the department did, that based on flawed OLC opinions, you can't indict a sitting president, and then you were to later take the position once they leave office, that as a practical prudential matter, you shouldn't either investigate or prosecute a former president because it would be too divisive or seem too political, then the president becomes effectively above the law. That's a proposition I don't think the founders would have ever countenanced. And in my view, you can indict a sitting president, even if prudentially you might defer the trial until after they leave office. But the idea that a president could escape accountability by operation of the statute of limitations, or because they stayed in office long enough, or because there was a sufficient reluctance once they left office to do something that, even though valid and based on the evidence, might be deemed political, that's a dangerous idea. Future presidents would walk away from that, much as our last president might walk away from these circumstances thinking they really are immune from any accountability. And so I think that if the evidence is sufficient, if the Justice Department can prove the former president committed criminal acts, he should be prosecuted like any other American.
So when
finally, Rick, if I could, with respect to the president's not very thinly veiled and really not veiled at all threats, that should the Justice Department pursue him, that he would essentially unleash the dogs of war. The department cannot, I think, give into that kind of extortionary threat. The moment we do is the moment I think we can say this is the point where we really lost our democracy. So we've seen Trump make these threats over and over again. He made threats during the Russia investigation along similar lines that if Mueller were to find him to have committed a crime, that his supporters would bring about a violent response. And I think there was similar language he used during the Ukraine investigation, and now he's using it again. And we simply cannot give in to those kind of threats of violence.
So when I had asked you about the lessons of January 6th, you said, we need to look at this in the larger context of all the things that happened between Election Day and after January 6th. And I want to ask you if you think that what we saw was in the last election and post-election period was a one-time danger that has now passed, or if you think that there's a significant danger that as we look ahead to the 2024 presidential election and beyond, that the country is still in danger of attempts to subvert or sabotage election results.
Sadly, I think we are at greater risk as a democracy today than we were on January 6th. And I say that because I was convinced, quite erroneously, as it soon proved to be, that when the country saw what took place on January 6th, when the country saw the terrible end to which this big lie had brought us, to the point of violence on the Capitol, when the country saw that, if you persuade people, as the former president did, that whenever you lose an election, it's somehow illegitimate or fraudulent, and we can't trust our elections anymore to decide who should govern, that produces violence, because what is left but violence? I thought for sure in the days after January 6th that the country would repudiate that big lie and the big liar. But that didn't happen. And sadly, one of America's great political parties has used that big lie around the country to usher in a new generation of Jim Crow laws meant to disenfranchise people, particularly people of color. They've used it to run out of town local elections officials, sometimes with death threats, and to try to defeat elections officials who upheld the rule of law, with candidates running on a platform of overturning the next election if it doesn't go their way. And so we are more vulnerable now, not less. And so I think we all need to be mindful of the danger, and we need to figure out what we can do in our own capacity to defend our elections infrastructure and the rule of law, because there's nothing inevitable about it. And I think it's come as a rude shock to so many of us that our democracy is not self-effectuating, that every generation, it turns out, needs to struggle to maintain our democracy and defend our democracy. I look forward, I like to say, the day when I can go back to fighting with Liz Cheney. But right now, Democrats and Republicans who support our democracy and our elections infrastructure need to make common cause to defend our democracy.
And that's exactly where I want to turn now, is to first what Congress can do and what the rest of us can do. And I want to start in terms of Congress by talking about changes to the Electoral Count Act. The Electoral Count Act is the 1887 law that governs how Congress goes through the process of formally recognizing each state's electoral college votes. There were lots of attempts to try to, I think, misread the language in there to say either that the vice president had the power to unilaterally reject votes, or to argue that state legislatures could send in those alternative slates of electors. And now there's legislation, both on the House side, the Cheney-Lofgren bill, and on the Senate side, the Collins-Manchin bill, that actually look like a chance to pass bipartisan election-related legislation, something that hasn't happened, I think, in any significant way since right after Bush versus Gore, when Congress passed the Help America Vote Act. Are you a supporter of this bill? Do you see differences between the House and Senate bill? What do you think is going to happen with this attempt to change the Electoral Count Act?
Rick, I'm a strong supporter of the bill, and I also want to thank you for all of the scholarship you've done on these issues and the degree to which you've helped illuminate the debate. I think this may be the single most important reform that comes out of our committee. And there are differences between the House and Senate measures. I think the House measure goes further. It requires a higher threshold, for example, to challenge the electoral count votes from a particular state. In the House, it would require a third of both houses. It currently requires just a single member from each house. We also, in the bill, very importantly, set out that a state can't change how the election procedures are to be carried out after the fact. That is, can't decide after a vote doesn't go the way a majority in the legislature wanted, that somehow they can change the rules after the fact. And that may be the most important provision of these bills. I will say this, though, as important as they are, these bills, and I do think we have a good chance of getting a version, one or the other, or some hybrid of the two, passed, because they don't cut either way politically. They don't help one party or the other. They just help remove any ambiguity that could lead to a real constitutional crisis. We were lucky that the vote wasn't close in the last presidential election. If it came down to a single state and it came down to a single interpretation of a single provision in that old 1880s legislation, then we would be in serious trouble. But we are still very vulnerable. The Constitution does confer on the states great power in terms of the conduct of elections. And you could have a state that decides in the most anti-democratic way before an election that it wishes to reserve to itself the right after the election to make a unilateral declaration of fraud based on no evidence more than its desire to declare fraud and overturn the results in that state, which obviously has broad impacts beyond any particular state, since a single state might decide who should govern the entire country. So I do think we have a great shot at getting this bill passed. The bill will help. But my chief takeaway from two impeachments and an insurrection is that you can have the best written constitution in the world, and I believe that we do. And you can have some of the best written laws meant to constrain the worst abuses of human nature. And I don't know what that we do, but we're trying. And none of it will be enough if people don't give meaning to their oath of office. And if that oath isn't informed by ideas of right and wrong, and if people are unwilling to accept the basic truth, then none of it is really enough.
Let me just remind those who are watching that if you have questions, please.
And what would you do? I'm going to vote again. I'll be right back.
All right. So I'd like to remind everyone that as Representative Schiff goes off to the House floor to cast a vote, that you can submit your questions using the Q&A box. We already have 8 questions in there. I won't get to all of them, but I will try to get to some as we work through this. As we're waiting, let me remind you of an upcoming event on, get the right date here. On October 27th at noon Pacific, I will be in conversation with the New York Times' Maggie Haberman on the topic of Trumpism and the future of American democracy. All of the programs are recorded and available for you. And with Congressman Schiff back, let me, before we turn to other things besides the reform of the Electoral Count Act, I want to get into the weeds. And one of the things I thought is that there's one positive thing that came out of all of the controversies during the Trump years is that people learned about all kinds of sections of the Constitution that no one had paid attention to before. I mean, the Emoluments Clause was not something that was on people's minds before this. And there is one interesting provision in the House bill. I don't know if you've even delved into it that deeply yet. That's not in the Senate bill. The Senate bill just raises the threshold for objections, as you mentioned. But the House bill lists different reasons for objections. And one of the reasons that's listed there, kind of technical, is someone is ineligible to serve because they violated Section 3 of the 14th Amendment. And that section of the 14th Amendment, this is a post-Civil War amendment, so we're talking about the 1860s. It said if you participated in an insurrection, you're not eligible to run for office, right? This was aimed at the Confederacy. But today there are active lawsuits trying to disqualify different members of Congress or candidates for Congress from running for office on grounds that they helped to facilitate the events that led to January 6th and to the attempt to overturn the election results. And some have argued that Donald Trump himself should not be considered as eligible to run for office in 2024. So I want you to imagine that, whether the House bill passes and it's explicitly in there, or the Senate bill passes and it's implicit, do you think that it's a potential grounds? Let's say Trump gets more votes than Biden. We have Trump versus Biden too. Do you think it's a potential grounds to claim that even if Donald Trump got more votes than Joe Biden in the Electoral College, that he would be ineligible to serve as president?
Well, I think that in my view, he certainly qualifies for insurrectionists having incited an insurrection against the government. The challenge that we have faced with Section 3 of the 14th Amendment is how is that section enforced? And one of the things that we are deliberating about is whether among our recommendations and among the legislation that come out of the work of our committee, should we also put forward legislation to clarify who has standing and in what ways you would enforce Section 3 of the 14th Amendment. So that is something that we are considering. I think that as a practical matter, deciding after an election that someone who won can't be seated because they committed an act of insurrection when people voted for that person is a pretty tough path. But I do think that we would benefit from, with respect, frankly, to both the provisions you mentioned, both that section of the 14th Amendment, but also the Emoluments Clause, benefit from legislation clarifying who has standing, under what circumstances, how can it be enforced, so that those provisions of the Constitution can be given meaning.
Some have suggested that if Donald Trump were to be considered for falling under Section 3 of the 14th Amendment, that Congress could decide that now and pass a resolution. That obviously is not going to happen if Republicans retake control of the House, which is certainly a possibility after November's elections. Do you think that something like that is potentially on the table? And given the composition of the Senate and given what happened in the second impeachment, do you think that that would just be a futile political exercise, whether or not it might be legally and morally justified?
It's hard for me to see that as a practical path. That after two impeachments in which the Senate failed to convict, notwithstanding the overwhelming evidence, that you could, with a lesser vote, with a majority vote, accomplish the goal of disqualifying someone from serving in office again. My own feeling, and I know there's a desire among a great many millions of Americans to find a way to move past this period and to not have to go through either the danger or the reality of another Trump presidency, to put hope in vehicles like the 14th Amendment, to put hope in a prosecutor somewhere, anywhere, to rescue us from this danger. And my feeling is that we ought to conservatively expect that the only people capable of rescuing us from this danger are ourselves, that he's going to have to be voted down again and defeated again. And it may be that, circumstances change and maybe a prosecutor does come forward. Maybe the Justice Department simply cannot ignore the volume of evidence at Mar-a-Lago. But I think practically, and particularly after people put so much hope in Bob Mueller, it would be far more prudent to expect that, no, the people are going to have to do this. And I do think one of the, salient impacts that the January 6th committee has had is to help inform that public of what a danger the former president represents, of what he was engaged in. So the public understands his role in insurrection, even if there's not a means, practical means to apply that section of the 14th Amendment.
I should point out one of the questions suggests another possible avenue would be for Congress to authorize a federal lawsuit that would determine, but that of course would put the question in the hands of the federal courts, which may raise similar problems. And I did want to turn to that issue as one more question under this, under the Electoral Count Act reforms. So one of the potential dangers in 2024 is that you'll have a governor, say a Doug Mastriano or a Kerry Lake, who decides, let's say in Arizona or Pennsylvania, again, it's Trump versus Biden too. Biden appears to be the winner, but the governor says, I don't believe the election results. I'm going to send in a certificate for Trump. And there's a specific provision in both versions, both the House and Senate versions of the bill, that would authorize a suit in federal court to essentially mandamus, require that certificate be put in that reflects the will of the voters, and those votes can be counted. Do you have confidence in the federal courts to do the right thing in these circumstances? There's so much politicization thinking about the Supreme Court today. Justice Alito made comments about people in the Wall Street Journal yesterday about people casting aspersions on legitimacy of the court. Do you have faith in federal courts when it comes to trying to prevent election subversion?
Well, it's certainly deeply ironic to hear Justice Alito talking about that, given the degree to which his own comments have resulted in discredit of the court. I think that the challenge is in a circumstance such as the one you described, where a governor attempts to thwart the will of the people of his state, to ignore the popular vote of his state, to ignore the state law that dictates that the electoral count votes go to the winner of the popular vote. Who should decide? And ultimately, there are only a couple options, and one is that the court decide, and the other is the Congress decide. And what we try to do in the act is set about the circumstances in which we think the Congress is the right body to decide, and which we think that the court is the right body to decide. Do I have confidence that the court would get it right? It's hard to have that confidence after Bush v. Gore, in my view. And it's hard to have that confidence. It's even more difficult to have the confidence today, given just how partisan this court has become. My own view of the Dobbs decision is that it was not a conservative legal decision. A conservative court would show some deference to precedent. This was a partisan decision based on in my view, reactionary social agenda. And are we to believe that a court that would act, in my view, in such a blatant way to overturn precedent to accomplish a social agenda would feel bound by precedent when it came to choosing a president that might impact that same social agenda? It's hard to have that confidence, which is why I think it was such a terrible disservice that Mitch McConnell and others did in withholding an appointment from Barack Obama and then forcing an appointment on the country while people were literally voting for Joe Biden in the most hypocritical fashion. The impact of which was to stack the court in such a way that it has really undermined public confidence in the independence of that body. And for that reason, I favor unstacking the court by expanding the court. It's also why provisions like the one you cite give me heartburn, even though I think they're better than existing law and probably the right approach. But I am deeply concerned with the direction of the court, and now when we have to entrust decisions like this to that kind of a court.
So we've talked about Electoral Count Act reform. Is there anything else you think Congress should do and could come together to do? I'll say one thing that I've called for.
Rick, can you hold that thought? I'm going to run a vote, and I'll be right back.
Yes. And I am beginning to get to your questions that are in the Q&A box. We're speaking with Congressman Adam Schiff about lessons from the January 6th conference. As we're waiting for him to come back from voting on the floor of the House, let me also tell you that there are recordings of some of the earlier sessions in this webinar series that are available on the Safeguarding Democracy website, safeguardingdemocracyproject.org. One of those earlier sessions involved a discussion for the Electoral Count Act, and another one involved a Supreme Court case called Moore versus Harper, which the court will hear next term on the, or next, in this coming term on the independent state legislature doctrine. So Congressman Schiff is back with us. And so I want to turn to beyond the Electoral Count Act and ask, what about other legislation? One of the things that I've been calling for is a requirement that all voters cast ballots on voting machines that produce a piece of paper that could be counted, a piece of physical evidence. There are about, I think, according to the Brennan Center, about 9 or 10% of American voters who vote on wholly electronic voting machines. And I think it was so important during the 2020 election, post-election period, that the Georgia Secretary of State was able to have every single ballot counted by hand. I don't know if you have any insight into why that kind of provision was not included in the bipartisan legislation. If you think there's any chance of something like that, I don't think that's a Democratic or Republican issue. I think that's an issue of election integrity.
Yeah, Rick, I completely agree, and I have also been championing legislation to insist on a paper trail in every elections jurisdiction, and that has been part of some of the House passed bills in the past. To ensure that we would have the opportunity to do a paper audit, as Georgia did, a hand recount of all of the actual physically marked ballots. In terms of why it wasn't included in the bill that we have put forward, the bill we put forward is really focused on amending the Electoral Count Act. So it doesn't include legislation on broader voting reforms. In terms of other legislation, some of the most important bills to protect our democracy have already been put forward and have already passed the House. I would put in that category HR 1 that makes a broad range of changes to our system to do away with the gerrymander and to attack these efforts at voter disenfranchisement, as well as the John Lewis voting rights legislation. The third bill I would mention, I have a parochial interest in because it's my own bill, the Protecting Our Democracy Act, which is what I've been describing as our own list of post-Watergate reforms to address so many of the abuses we saw over the last 4 years. So that legislation expedites enforcement of congressional subpoenas, so you can't have a president simply stonewall subpoenas. It would strengthen the independence of the Inspector General, so they can't be fired except for good cause. It would attack the problem of using temporary Senate appointments to evade Senate confirmation, and about a dozen other things. And these bills have all passed the House. The impediment is the filibuster in the Senate. And I think probably to do more than the Electoral Count Act, which we might actually be able to get through without even, with a filibuster, because we have the support of a number of senators, Republican senators. For these other bills, though, we would need to do away with the filibuster to accomplish something more substantial. And it may very well be, although I can't for the life of me understand why, even a simple bill to require a paper trail with ballots might be filibustered by Republican senators objecting that we are trying to tell states how to conduct their elections. At least that's the ostensible argument they make. I think the practical point, though, is a very different one, which is the Republican business model has been one of disenfranchisement. I think the GOP understands that its views on abortion and its views on other issues are deeply unpopular with the American people. And their only hope of gaining and keeping power with an unpopular agenda is if they can make it more and more difficult for Americans to vote, particularly Americans they believe aren't supportive of their agenda. And often that means people of color. And so things that either guarantee the sanctity of the ballot or that attack these artificial restrictions meant to make it harder for people to vote, they're not going to go along with. They're going to filibuster. Just to give you all an illustration of concrete example of what we're talking about, California has moved to make it easier for people to vote. In other places, like in Wisconsin, a Republican governor and legislature pushed legislation successfully to provide that if you're registered to vote in college, at your college, and you change dormitories from one year to another, you have to re-register to vote. And if you look at, what percentage of young people participated before and after that vote, you can see a dramatic fall off in participation. Sadly, those efforts, which are not even thinly disguised, are successful in making it hard for people to vote.
One of the viewers asks the question about protecting local election officials. That's another thing that Congress could do, but also could be done on the state and local level. Our elections are so decentralized. So even looking beyond Congress, what do you think states should be doing, local governments should be doing, the average person should be doing to try to assure that we can continue to have free and fair elections in this country?
Well, I think there's a role for all of us to play, particularly in the election we have coming up, in less than 50 days. In California, as I mentioned, we're fortunate. We've expanded the right to vote. We made it more accessible for people. But in other states, they've changed the rules to try to make it more difficult for people to vote. And many people may not be aware of how the rules have changed, and their vote may not be counted because they're expecting to be able to cast their vote the same way they cast in the last election. And so there's a real need around the country for people who are able to, on a grassroots level, help people vote, make sure to help get out good information about what's necessary. And if they have been purged from the voter rolls, how to check to make sure that they're still on the voter rolls, or how to get back on the voter rolls, what identification now may be required in different places. If their polling station has been closed down because they're in an urban area in an effort to discourage people in urban areas from voting, then where do they need to go to vote? And how can they help get transportation to get to vote? So I do think that this next election is critical, and people can play a very important grassroots role. Those like yourselves with legal skills can help with poll watching and making sure that people have the right to vote and vote provisionally if necessary, if there's any dispute about their ability to vote. So I think this is something everyone can do in the very near future. And if the balance changes sufficiently in the Senate, then we can put some of these protections into law. We can overcome the filibuster with a couple more senators willing to put voting rights above this arcane Senate rule. Then we can make law many of these protections so that the work to protect the right to vote in the next election isn't so difficult.
I want to ask you to be a little reflective now in terms of looking back at the first and second impeachment. I just saw a poll yesterday showing, I think it was 61% of Republican voters believing that the last election was stolen. We had the issue of the first impeachment of Donald Trump, where you were a lead manager related to the potential extortion of a Ukrainian leader. The second impeachment, which involved the events leading to the January 6th insurrection. And yet there was no conviction. It wasn't even close because of the supermajority rule that's required in the Senate for conviction. Do you think that it was worth bringing those charges of impeachment? And if this evidence was not sufficient, are there any facts that could have led to, or a different approach that could have led to a different result, given the current composition of the House and Senate and the polarization there?
I think it was very important that the House pursued both impeachments. And, I should say that before the Ukraine facts came to light, there was a desire by many of my colleagues to impeach Donald Trump on his Russia misconduct. And I resisted that until Bob Mueller was finished with his work. I wanted to make sure that we understood the full facts before we decided what the appropriate remedy ought to be. So I wasn't one to rush into impeachment. And what I weighed at the time was, what is the impact of not holding the president accountable? And what's the impact of holding him accountable, but then resulting in acquittal? Would that be used as an argument that this was somehow not impeachable conduct? What tipped the scales for me was, after he was not held accountable for his Russian misconduct, he went on to commit worse misconduct vis-a-vis Ukraine by extorting the president of that country, Zelensky, by withholding $400 million in military aid to try to pressure him to smear his opponent before the election. And sadly, when he wasn't held accountable for that conduct, it led to even worse misconduct in the form of an insurrection. If I had any question about whether we might have done things differently in the first impeachment, which resulted in a bipartisan vote for conviction, but not enough by any means to remove him, if I had any question about it, that question was answered with the second impeachment, which is, even when everything we warned about in the first impeachment came to reality, came to fruition, and we warned if he wasn't held accountable that the odds that he would go on and try to cheat in new and worse ways were not 5, not 10, not 50%, but 100%. When he did go on to try to cheat in a much worse way, to the point where the jury of the senators actually had to run for their lives, it still wasn't enough. And so you ask the question, well, if that's not enough, if the senator's own lives being put at risk by the president wasn't enough to get them to uphold their constitutional duty, then what would be? And the answer is, I don't know. I don't know what would be. I keep coming back to something Robert Caro, the historian, once said in an interview. He said, power doesn't corrupt as much as it reveals. It doesn't always reveal us for our best, but it says a lot about who we are. Well, power revealed a lot about the people I serve with in the House and in the Senate. Many of whom I admired and respected because I believed that they believed what they were saying, turned out not to believe it at all. Or if they did, none of it really mattered compared to holding their job. And so at the end of the day, I think if we ever needed, it underscored how important character is in office. We have seen the evidence now of what a lack of character in the Oval Office does to a country, and what a lack of character in the House and Senate can lead to. Because after all, if Donald Trump hadn't had the enablers in the House and Senate, he could have never gotten away with half of the misconduct that he engaged in as president.
So one of the arguments I've made that has gotten a lot of pushback from people on the left is that there was a moment right after Donald Trump left office. It was that moment when Mitch McConnell gave this speech upholding the rule of law and excoriating Trump for trying to steal the election, that Democrats should have used that moment to try to go after Section 3 of the 14th Amendment, try to make changes so that the election results in the future would be more secure. But they spent a year on a bill, the For the People Act, that was clearly not going to overcome a filibuster, and Joe Manchin was not going to break the filibuster for voting rights. Do you think that tactically there was a moment and that moment passed, or do you think that we really never had an opportunity to have a filibuster-proof majority in the Senate to get some more beyond Electoral Count Act reform, get more voting reform that could have helped to secure elections in this country?
Let me vote. I will come back and happy to try.
All right, while Congressman Schiff steps away for what I think will be the last time, I will be, we have about 10 minutes left. I'll be turning to more of your questions. I've already asked some of them. As I was saying before, the Congressman had to take his last break. We had a very interesting discussion about the Moore versus Harper case, which the Supreme Court is going to hear in the upcoming term. This is a case out of North Carolina, where the state of North Carolina's Supreme Court ruled that partisan gerrymandering violated the state constitution. And there's a claim as to whether or not that ruling itself violated the federal constitution. So if that interests you, you can check out that earlier webinar that's on our website. All right, back to Congressman Schiff. So the question is, what did the moment pass?
And Rick, I don't know whether by the question you mean, would we have been better off pursuing disqualification based on the 14th Amendment, Section 3, as opposed to impeachment? Or you mean even after the impeachment, should we have moved to then pass an enforcement mechanism for that clause of the 14th Amendment? I would say that let's remember what Mitch McConnell did. Mitch McConnell delayed the beginning of the trial, the second trial, until after the former president left office, and then claimed that he couldn't vote to convict even though the president was guilty, because the president was no longer in office. If the Republican Senate leader is going to engage in that kind of tactic, then my guess is he would do the same with an effort to provide an enforcement mechanism that would have had the same result. Had the Senate gone along, not filibustered, or there'd been an opportunity to overcome a filibuster, to pass something to allow the Congress to disqualify Donald Trump from running again. And Mitch McConnell felt that that was politically not useful to him, as evidently he concluded in the impeachment. My guess is he would have concluded that about the insurrection provision avenue as well. So I don't imagine we would be in a better place, I guess is my sense.
Yeah, I guess I was asking more broadly about the Electoral Count Act reform and other kinds of reform besides that, like the paper trails and things like that. But
oh, I see. Whether we should have gone with the just in a change the Electoral Count Act rather than pushing for all of the changes in HR 1.
Right, but not just the Electoral Count Act, other things like raising the penalties for trying to interfere with elections and protecting election workers and those kinds of things.
Yeah, you can write this off to some healthy cynicism or skepticism. But again, the business model for Mitch McConnell has been disenfranchisement for a long time. That's also Kevin McCarthy's business model. They're not interested in making it easier to vote. They are very interested in making it more difficult for people to vote. And so this wasn't going to be done with their support, not in a smallish way and not in the largest way. So I think the only path is probably to overcome the filibuster. And to me, it's a mystery how people can elevate the filibuster, this non-constitutionally derived rule, they can elevate that over protecting people's right to vote. But at least 2 Democratic senators do, and all the Republican senators appear to. And until that balance changes, I think it's going to be difficult to pass any bill, frankly, that protects the right to vote or makes it easier for people to vote.
Okay, our final question comes from one of our viewers who asks, given the possibility that we may see a Speaker of the House or a President pro tem of the Senate of a different political party than the president after the midterms, do you think that Congress should revise the Presidential Succession Act to restore the order of succession to the president's cabinet in order of seniority as it existed at the time of the Eisenhower administration? That's a provision that might discourage, in example, people from leaving office or impeaching presidents because it could lead to a change in parties of who controls the executive branch.
Yeah, that's an interesting question. I honestly haven't given much thought to that. I suppose it could have that impact. That is, the current scheme could have that impact of discouraging an appropriate impeachment. But I would really need to give that more thought. I guess at the end of the day, there's not much that I would change about the impeachment process. Now, I know the question is about succession, but I don't think the problem is with the 2/3 requirement for impeachment, or the way House conducts impeachments, or the way the senators have the power to control the nature of the trial, even though in the case of the first impeachment and ultimately the second, particularly in the first, they controlled it by not allowing witnesses. The problem is that I think you just had too many people not operating in good faith, not doing their constitutional duty. And I'm not sure there's a way to legislate around that. But I'll give more thought to the question of succession. I hadn't really thought about it in the context of what incentive or disincentive that provides Congress in terms of an impeachment of an errant president.
Well, I've really appreciated this conversation, especially your emphasis on good faith and how ultimately democracy is in all of our hands as we look forward to 2022 and 2024. Thank you all for attending. You can find more events at safeguardingdemocracyproject.org. I'm Rick Hasen. Once again, thank you, Congressman Schiff, for joining us today.
My pleasure. Thank you.